Most wills include provisions whereby the will maker appoints one or more persons to be their executors, with responsibility to administer the estate after they die. In many cases, once the will maker dies, the executors need to apply to court for what is called a grant of probate, which is official recognition that the will is valid and enforceable. I'm John Gallagher from Argon Law, and I'd like to tell you a little more about applying for probate in Queensland. The tasks of an executor include arranging for funds deposited or invested with banks or other institutions to be released. Those institutions will generally insist on seeing proof that probate has been granted before releasing the funds. However, many will have a threshold value below which they will release funds on citing only a certified copy of the will and the death certificate. So executors don't automatically need to obtain a grant of probate. If the estate is only small, you may be able to avoid the expense of applying for a grant. But if a grant is required, then the process involves proving to the Supreme Court that the will is the last will of the person who has died. The process includes advertising your intention to make the application, and then, no less than 2 weeks later, lodging all relevant paperwork, including supporting affidavits, with the court. At Argon Law, we can help with that process and any other aspect of estate administration. For more advice and information about wills and estate law, along with many other legal topics, be sure to subscribe to our video blog or take a look at our website.